Miss Carolyn Stapleton, retired law enforcement victim advocate. Oh, that's the advocate now. And Brandon, Melissa, if y'all want to come together.
Brandy's the one that called me about this panel, and I ran off two cases that I was very familiar with. That speaks to really what you were talking about. Okay, one of them was a sex offender. He was named Eddie Orange, and I was an advocate for one of the children that he raped again in 2006. But in 1994, he pled guilty to raping relatives, both girls, and they were young children too. And he was sentenced to 30 years. And the sentence was he pled guilty to 10 counts of incest to 2 blood relatives. And the sentence was 30 years, but it was suspended with a 5-year probation. Okay? So then fast forward, and we get, that was in 1994. Fast forward to 2006, and I've got in my office little girls, again, relatives of his. The 12-year-old is pregnant. Yes. And the 13-year-old he had molested also. So here's some of what the article says. In 1994, he was sentenced to 30 years, but through a plea agreement, his sentence was suspended and he ended up on probation for 5 years. Since then, he remarried and had 3 additional children. Tuesday, which would have been in the year of 2005 and 2006, which I was a victim advocate for the sheriff's office. He was arrested after detectives say the state police crime lab positively identified Orange as the father of an infant born from a 12-year-old mother, a girl related to Orange. So yes, they do reoffend. Yes, they do get off on plea bargains. Everything you were saying. And this is a case that I was personally involved with. And he had pled guilty to 10 counts of incest on the 2 other blood relatives. So he pled guilty, and with all of that, he faced no jail time. Then I have another person, speaking about sexual predators, and his name is Tommy Mouton, that, I was familiar with through my work with Victims Advocate. I don't know if y'all are aware of him. But he was arrested and put in a state prison in 1993 for molesting a prepubescent girl. And while in prison, he created a manifesto on how to kidnap, rape, and murder children. Wow. He was fixing to get out of jail, and the DA's office was like, how do we keep this person in there? Because that goes back to chemical castration and stuff. This man was in jail, and the sickness is in their brain. So the whole time he was thinking on how he could do this again, and created a manifesto, which was found in his prison cell by one of the jailers. In the manifesto, Mouton drew pornographic pictures of children, given names such as Tanya, their ages 12 or 13. He drew pictures of children girls being dismembered on a table saw. Images and journals found in Mouton's cell in Claiborne Parish Prison depicted scenes and stories of torture. Then he went on to teach how to lure these little girls, and he described ways of capturing them from their home. In 1980, the case that he was jailed for, that he had molested a little 6-year-old over a period of 21 months. He was sentenced to 10 years, and he was going to get out. So the DA's office in Claiborne Parish found this manifesto, and they brought it before and introduced additional charges, which was pled guilty to possession of child pornography, although it was his child pornography, and he was given more time in 1994. He was released from prison in 2008. He was required to register as a sex offender for 25 years. He did not register. He was put back in jail for another 5 years in prison till 2010. And then in 2009, the legislature enacted a law requiring imprisoned convicted sex offenders to undergo an evaluation for sex offender assessment panels. Nobody has mentioned that. I mean, the acronym is SOAP. And the experts who determine whether or not the inmates are a violent sexual offenders. Since then, thousands of inmates have appeared before the panel, but only 47 have been deemed child sexual predators, of which Mr. Mouton is one in this class. This was the DA talking to the judge because he was fixing to get out again. And he was being held on bond for a $30,000 bond. And the DA was trying to get that removed because he was ordered to wear a GPS monitor for the rest of his life. And then he got out in Jefferson Parish, and within days, they were looking for him. And they had to get a task force, a marshal's task force, to find him. And when they found him, he had several unused condoms and a small bottle of lubricant. And this was, the DA said, wearing the GPS monitors clearly did not work, at least in Mr. Mouton's case. So he was sentenced to life. He went through all of that, but he was let back out. And the first thing he didn't do, so for the second time for not registering, he got 20 years in prison. And that was back in I think that was back in 2013. So that means, yeah, it was 2013. He was sentenced to 20 years for that. So is he out right now? I tried to find out, but the APRIS account where you can check online to see if a prisoner, it was down for that prison. And that's quite often the case, which that's a failure for victims. A lot of times they go online to see if their prisoner is still in jail, and the jail monitoring through APRIS is down. And sometimes that's because they failed when APRIS checks to see if the head count is right. If that head count is wrong, APRIS will shut that jail down. Yeah. So then a prisoner...
That's interesting.
Yeah.
And you say that happens quite often. So.
It does happen, yes. If there is an inaccurate count in a jail system, APRIS, who runs they call it, we have the Louisiana Automated Victim Notification System. APRIS will shut that jail down until they find out what's going on. If it's a computer glitch, or if there's somebody out and they were released, which is what that would indicate. If APRIS shows more people in the jail and the jail shows less people, even by one, they need to know who's missing, and are they really missing, or is this just a computer glitch? Because if the victim has registered online, which I did against all my victims, so I knew when the jail went down in East Baton Rouge Parish, and I was also the coordinator between APRIS and the East Baton Rouge Parish Jail. And so if our jail system went down, I was on the phone with APRIS itself, and I was also on the phone with Baton Rouge City Police Department, who ran our computer system for our jail service, although it's the sheriff's office that actually runs the jail, to find out what was going on and how soon could we get this thing back up and running. So yeah, so for this guy, for me to check to find out is he still in jail, it was down.
So this is recently, I take it.
Yeah, this was just a few days ago.
This brings up
This is a lot of jails in Louisiana that they are not in compliance with APRIS. So their jail system for our Louisiana Automated Victim Notification System will be down, and victims cannot use it.
So this is our local, this is our state.
This is state jails. That's right. And another thing, though, that we had, it went down after I left the sheriff's department. But we also have a victim registration and notification form. And just a week ago, I spoke with a local law enforcement, and he was a veteran, but he had never attended one of my classes because I was around when APRS came along. I was around. We had a 1-part form, and I got it changed to a 5-part form that we use to this day. And he called it the domestic violence form. Well, he got a training over the telephone. And that form is for all victims of violent crimes, including sexual victims. So if police are still, because that's the backup, that form has 5 parts. So if police at the time that an arrest is made gets their victim, which a lot of times is children, so the parent would fill it out. And let's just say that the automated system goes down. That paper form is supposed to be torn off, and a piece of it and one of the sheets goes to the parish jail with that offender. And the other sheet goes to the clerk of court, and another sheet goes to the DA's office. Another sheet, it's 5 sheets because that form has to go 5 places immediately. And when I first started in victim services, we had a 1-sheet form. It had no instructions. And I went to the Commission on Law Enforcement, and I said, "What the heck is this?" And I'm not going to say who told me, but somebody said, "Well, it's really a gray area, it was designed to be gray." And I said, "Well, you win. It's invisible. Nobody's using it." And I had to look it up, and I did. I looked up the RS code 468141, crime victims' rights, and then I found, and it's all over the place where that form is supposed to go. And then
Happening now?
yeah, people will write. If they think it's a domestic violence form, they're clearly not going to be giving it around the state. I know Star is very active in where they're located, but what about the other parishes where they're not? So I know for a fact it's not given out to all victims. And this person, right then, by calling it the domestic violence form, he was misled. And if you read that form, it lists all the crimes that it covers, so it's on the form. And that was designed so that each sheet for law enforcement has instructions. And I called some of my friends, and that's what started the panel. And that's why we have a 5-sheet form, because it didn't exist. And when I first said, "This doesn't work," I was told, "Well, that's the way it is because it's promulgated by the Louisiana Commission on Law Enforcement." I said, "Well, this is not the last word on this." And we didn't. We had a panel and we got it changed, but still yet to this day. So let's say Lavens goes down. If this form has been filled out, it went with that accused person to jail. So when they're released, whether or not the Laven system is up, that form should be in their jail, their jacket, and it says, "Okay, we've got a victim. This is their phone number." It has on the jail form who they're supposed to call, and then on the back it shows they're supposed to write down how many times they reached out to that person. So even if that system goes down, if they filled out the paper form, which they're supposed to do at the time of arrest, they're supposed to give the victim the option. And at the bottom of it, if the victim refuses, they can put victim refuse. That means they did their job. And so we've got a safety net there. But if the safety net's not being used, I mean, you got victims that's going to fall through the system, and the person's going to be let back out on the streets, and they're not going to be called. So yeah, both things that you said, though, getting back to this, we've got plea bargains, and we got people that get out on it. And then if it's an incest, a person that likes to rape his own children or his little nieces or something, like they said, what did he do? He got out, he remarried, he had 3 more children. And then, fast forward, and we've got a 12-year-old pregnant and a 13-year-old that's been raped too. And then you got Tommy Mouton. I mean, a manifesto on how to dismember and how to kidnap and rape children. This is all in his mind forever and ever and ever. He will be thinking. I don't care if you castrate him, put a GPS monitor. And they said that in California, and I think it was Kentucky. They actually some states, this is what the DA said to the judge at that time. He said that in some states such as California and Kansas, they have laws allowing authorities to involuntarily place people such as Mouton in mental institutions for evaluations. So that's another thing that is being done, because really it is a mental problem. It's not fixable. And with all the conferences that I attended with the Department of Justice and state, and we had experts, the one thing they all agreed on when we were at these conferences, pedophilia is a lifelong disease, not curable. It is a mental illness, but there is no medicine for it because it's in the mind. So if they can't do it the normal way to children, as you can see with Tommy Mouton, they will think of other ways to sexually violate these children. And I mean, he had thoughts of how to kill them and stuff like that, and all little girls.
So you answered my question, because I was going to ask you, so then what do we do if castration is not going to be part of the solution?
Because they're insane.
Okay, Ms. Lamondre.
Yeah, I wanted to touch on a few points about the forum, because there was, I think it was a couple of years ago, and I think I called you, Carolyn, about, we had a client at Star who, she was sexually abused as a child, and it was by her biological father, but her mom was not supportive, kind of going back to the financial support and that kind of thing. But what ended up happening is she ended up being adopted by some other family members. But her mom, because the mom filled out the form, was always the one who received notification. Well, all of a sudden, she's and I don't even remember how she found out, but some kind of way he was going to be released, but she had never received notification. So we got a process set up to where she would then start receiving notification. So my concern, though, to kind of address that point, is when children become adults, to ensure that they there's some sort of way for us
that it moves
to follow
forward
up with ensuring that. But even still, in that situation, and obviously times have changed. She's an adult now. It's the laws has changed, but that is a point I did want to make about that. And then, the other thing about filling out the form that Carolyn and I always have talked about when it comes to victim rights, we have amazing victim rights, but we have no enforcement power if they are violated. And so we don't want it to be, too punitive in nature, where it's going to cost certain things. But in the end, and, we've talked at length about the states that do have panels where you go before them if you violate a victim's right. Because the thing is, you can't overturn a sentence. You can't overturn, because of the constitutional protections against double jeopardy and all. But you can see from the news, I mean, what's the good of having these notifications and all of these ways to be present and heard as a victim if you're never going to be given the opportunity to exercise your right? And as Shannon had pointed out, one of the things we talk about at STAR all the time is justice comes in many forms. For survivors, sometimes justice is, even if it is a plea deal, they may have wanted to say a victim impact statement. They may not have wanted a life sentence, but they wanted their voice to be heard. And it is a critical part of healing. So I do, going back, and I was terrified of the things you were talking about. So of course I looked him up. It says on there, his agency is offline or not participating.
There you go.
So even still, because I'm like, oh my gosh, is this guy in
I'm going to
jail?
dot my I's and cross my T's. Morgan knows that about me. Oh, yeah.
Yeah.
And that's something?
Head shaking in the back. I'm like, please tell me. Can y'all find out? Like, is he in jail? Please? Like, tell
really,
me.
please.
Because
Jesus.
and
Isn't that a shame?
Yeah, and I think that's where I think we do need to sort out, because clearly this person should never have come out of jail, and then, one of the things we also see is that perpetrators will continue to be perpetrators even in jail. And the sad thing is that in prisons, they're supposed to do an assessment for PREA purposes, so the Prison Rape Elimination Act, and too often people think, well, if you're in jail or you're a criminal, then you deserve to be raped, and that rape it doesn't matter. Rape is not okay in any situation, and in fact it normalizes rape when we somehow believe it's an appropriate punishment for people who have been convicted of any crimes. It's not an appropriate punishment for anyone. It's not appropriate to happen at all. So I just wanted to get on my soapbox for a second, and I'll step off.
Well, see, I moved forward after I retired. I was hired through a grant to be a victim advocate representing victims before the Probation and Parole Board. So my job was, when hearings were coming up, I would pull up the name of the offender and I would see if they had victims registered against them. But another thing that I think is a huge glitch in our system, which I never understood, was we have this form, it stays in the jacket of the prisoner, but yet when they get into DOC, they fill out another form.
Yeah. That's right.
And they never lose the right to fill out our original form, but our original form, if filled out, follows them to DOC. So why in the heck do you have to fill out another form, which automatically, if it's in their prison jacket, should be put into the computer system? And so, of course, with my job, I could pull up the names of the victims and make sure that they were notified. And sometimes they hadn't been notified. Like what Morgan was saying, the parent would be notified. But because being the type of person I was, I would see that a child had aged out, and I'd say, well, look, I need the name of your daughter because I need to know if she wants to be here. But that's me.
That's
but
you.
Right. That's 20-something years, and I'm a hardcore victims advocate, and I will stand up against anybody, over something. I don't even care. So, yes, I would follow through that, but that's me. I didn't care who I had to stand up and say, this is wrong, this needs to be changed. And I'll tell you what I tripped upon with that job was that our law under the Victims Registration and Notification Form, if they filled out that form, it says you shall be notified. But then being a part of an advocate in front of the Probation and Parole Board, they had, unknowingly to me, gone into state law and wrote that the person that they were to notify was the victim of the crime of conviction. And I said, are you kidding me? You can't plea bargain away a victim, but that's what you just did. That is not, I said, you're in conflict with our victim registration and notification form, and this has to change. And I walked out on that job so that I could get legislation changed, and did.
And I was going to say, I do know for a fact that has successfully not,
I got in touch with some district attorneys, and I said, guess what? This has to stop, and this is what's going on. And at first people didn't see it. I said, you can't plea bargain away a victim, and it's in conflict with our registration form that clearly states if you fill out this form, you shall be notified. And so we went back, Morgan knows, and it was clearly written in, and I've always wondered and worried that it would be undone again because I didn't know it was messed up the first time, except that God puts you where he wants you to be.
Yeah, and just to be clear too, in case for the people who don't understand maybe what we're talking about, when you become when there's an arrest for a crime, well, obviously a lot of times there are multiple victims and there can be individual charges, but when a plea deal happens, they may take one charge and convict based on that one individual charge. So what was happening is they were saying, well, all of the other victims, even though it resulted in a plea deal, they were not allowing all of those victims to be considered for notification purposes.
And to give a victim impact statement.
Exactly. So we made sure that the law was clear.
Yeah.
That's right. I don't want to say change because, to be honest,
it was just
supposed to be like that.
No, it wasn't.
It was sort of an internal thing that
I don't know how it happened, but it was in conflict with our registration form. So then, when it was redone, it was made very clear, that if they've registered with the registration form, they shall be notified by probation.
In 2017, when we did that.
I love it, and I'd been retired since 2014. So let me tell you something, they didn't like me at probation and parole, and they were the ones that got me the job. What can I say? But look, I am a victim's advocate, and I know victims' law. So when I met with them, like I said, I had my T's crossed and my I's dotted, and I knew where I was standing on firm ground. But back to some of you were talking about the dynamics as being a victim's advocate in my office. I did have mothers that came in, and I had them say, oh, well, this is just great. Now who's going to pay the bills? I had it. I mean, little girls. And then, though, I had other mothers that they were horrified, and they wanted this to go down, and they wanted their child to be protected. So I was on the Crime Victims Board, the Louisiana State Crime Victims Board. I was on there for about 10 years. But one of the things that was perfect for me as being a claims investigator and also being on the board, I knew where there were some holes that were falling through for victims, okay? So we had, under the Crime Victims Reparations Act, we had an area of loss of support, but it was only loss of support in deaths, like if the parent was killed or something. So my very first year as being on the board, because I had been saving this up, I said, look, we need to change something. I think that loss of support, because I had 2 victims at that very time that the mothers, they were going to be destitute. A man worked for Baton Rouge. A man worked for a very important firm here in Baton Rouge. He was convicted of molesting his little girl. So he was losing his job, going to jail, and boom, they were losing their home, everything. But they didn't get loss of support because that wasn't part of our crime victims reparations plan. And then I had another case where the guy owned a business, and he transferred everything into his father's name. So when he went to jail, same thing happened. The mother and the children got nothing because then the dad owned everything. So I went before the board, which I was on, and I said, look, I think that loss of support should be extended to include families of incest victims, because they're not going to get Social Security and they're not going to get child support. So automatically, in an instant, they lose everything. And we got $25,000 that we can award to that family, that if they need to move and need a down payment on a new home. One of the mothers went back to school, to nursing school, and the board unanimously approved it with me. But we had to go before legislature, and I was told by Louisiana Commission on Law Enforcement, well, you got to get somebody to sponsor the bill. And I said, no problem. I will. And don't you know, I get back into my office that afternoon. This is what I tell you about God. Francis Thomas's office called me, you know him, and said that he wanted to sponsor a bill for crime victims, and he didn't know what to do, but he's never lost anything. And did I know one? I said, I have the perfect bill for you.
Sounds just like him.
Yes, and it went through unanimously. So, you're placed where you need to be in people's lives. But we got that passed unanimously, and it's a reparations to this day. But that was some of the things. I did have both types of mothers in my office, and it went both ways. And of course, as an advocate, I did everything to help them. But that's some problems I see, that Morgan sees too, that our crime victims are still facing. The form is not routinely given out by law enforcement. APRS does go down in a lot of jails. And then if the form had been filled out, the victims would be notified, because it'd be in there from DOC when the Attorney General arrest them. And I mean, not the Attorney General, the give me my word, Hill or Moore them, when they send them to jail. Okay, that form is in there, and then when they go from there and they go to DOC, the form is going to follow them all the way through. And but if it's not given to them, if Lavens goes down, they have no way of knowing. But if it's given to them and and it says on our form, you can fill it out at any time. So say law enforcement doesn't give it, the DA's office, that was the word I was looking for, doesn't give it to you. That was a senior moment, doesn't give it to you. They can find out about it later, like through something like this, and they can say, I want to fill out my form, and they're never denied that right.
So law enforcement, I'm sorry, are you
I'm
sorry. Are you still talking? Okay. So law enforcement does not give out the form.
They're supposed to. It starts with law enforcement. It starts at the point of arrest.
So regardless, any law enforcement, so we're talking about local, state, whatever. So that's not happening. That certainly isn't. Well, it's
It
not
is in
happening.
some places.
It's some places. It's not happening all over. It's
No.
not consistent. And that's a question, because I like to know why. Why?
Well, there's
isn't
some
it?
lack of training. I mean, one thing is lack of training, and another thing is lack of give a darn. I know when the form first came out, I got the first case. I mean, the first case was delivered to my office, and I know for a fact that I had a captain tell me, I mean, I walk in there and it's sitting in the corner, and I said, what the heck? These should be in every, it should be in every squad car and everything. But he was just going to show me, well, we're not doing that. That changed. But that was the first response, and that was a person over other people. And so you take little bitty places where they don't have somebody like me as a victim's advocate who's willing to go up against a captain or something like that, or even knows the form exists. Because, I mean, all you have to do is call Louisiana Commission on Law Enforcement, and they will send you cases of it. And so I do know places where, I mean, in fact, I know places where if they book somebody into their jail, they better have that form with them, or they send them back to the victim and they say, get that form. And if the victim doesn't want to sign it, then that's what you put at the bottom of the form. The victim refused. The victim's not interested. There has to be something that shows that form was given to a victim. So it really depends on your sheriff or your police chief, and they can make it happen. Training and consequences, like Morgan said. There are places where there's consequences. There's places where if a victim's rights are not upheld, a judge is held in sanction. And I remember one of the cases that I learned about in another state, because they have an actual victims panel. And cases are reviewed if victims feel like their rights were not met, all the way up to a judge. And that judge can be fined. That judge can also be disbarred. And there was a case where a judge was being disbarred. This was many years ago when I was at a conference, and I made friends with a girl that was on the victim panel. So yes, in other states, there are consequences. There's fines, there's penalties. A judge can be removed from the bench.
We need to talk a little bit more about some of those actions or items, because you have really given us a lot of good food for thought in terms of other things that we need to look at. And so next meeting, which probably may be our last meeting, in terms of the time frame that we have, and what I will do probably going forward is I may continue this because so much has come out of this discussion in terms of where we have loose ends or gaps as it relates to services or enforcement. And so you have talked about at least three things, and so I like to understand. And so we will have DOC here. I'm going to request for them to come next month so that they can help us understand, because I like to know why the APRA system is going down and who's responsible for that. And I mean, how often is that happening?
In some jails, they don't care, months at a time, but not our jail. I mean, when it goes down, I know reporters, they will register against an offender. And so they know too when the system goes down, because if you've registered, you'll get a notification that the system has gone down. But like I said, if you're an actual victim and you were given the victim registration and notification form, that's your backup. That's the paperwork that says if he's let out, whether or not that system's working, you're going to be notified by the jail. But if you're never given the doggone form, victims don't know to ask for their rights because they don't even know they exist.
That's right. They don't know what they don't know, right?
No, they don't know what they don't know. That's why advocates are very important.
Well, Ms. Stapleton, I tell you, your testimony has been absolutely awesome, and your reference to being at the right place at the right time is so accurate, I believe. And so I thank you. Some 10 years later, you're still advocating.
I sure am. I think when it's your calling, it's your calling.
Yes, I agree with you.
And
I
that's
totally
what it
agree.
is. Yes, ma'am.
All right. Well, thank you so very much. But I have the three things I didn't even have to ask you. You gave them to me already, so I'm going to
Okay.
follow up on those.
Okay.
Yes. Thank you so much, Brandy, for inviting her to be here today.
Is this thing on? Yeah. I'm not gonna rehash everything I did at the last committee, but first of all, I'm gonna let everybody know something that's probably gonna shock even the person I'm talking about. I have more respect for the sex offender sitting in this committee than I do for the person that talked before me, even Carolyn. I have been in this building since 2008. Never once in my life on any issue from A to Z. And y'all know I'm here on pretty much anything and everything because of I'm not sitting here with a brain that looks like if my brain and skull wasn't caused by domestic violence in utero. My medical diagnosis would be a crania, and I'm about to be 40 in a few months. But because it's not natural, they say it's severe brain trauma, which was caused from my dad beating my mom when she was pregnant. People starting off their conversations insulting people that work for the state agencies. Because everybody that deals with different issues doesn't know everybody that is a victim of this situation or everybody who is a survivor. So just because the majority of some people that one person deals with has one viewpoint and deals with it one way, that's not the case for every child sex offender or child sex survivor in this state. And to say that recidivism is not common, well, DOC's model inmate is sitting in Rayburn. On the victim notification thing, the person that has kept him locked up and had him unanimously denied parole and also had his residence plan revoked in April of last year wasn't on his convicted victim. So I guess I owe the safety, and everybody owes the safety of this state in the last 3 years to the woman sitting next to me. Because my brothers were not Ty Michael Duquette's convicted victims. But I made a few phone calls thanks to stuff that she told me that I could do. And I was put on his notification list. They sent, like I said last month, they sent the notice to my mom of being deceased. I had to go through calling them, and they had sent it to my P.O. box. I went through all that. But not everybody knows about that. And also, for y'all that don't know, he's not serving a 30-year suspended sentence for being a first-time offender. Jimmy Swagger Ministries told my mother and the neighbor that caught him messing with my brothers. They knew he had victims before my two brothers. He hurt my two brothers in 1990. He wasn't convicted of the fact he's serving the suspended sentence for until 1994. That was after the media got in his face at his front door because he refused to register. He completed Teen Challenge, which was supposedly rehab, with flying colors. Judge allowed him to go there because he wanted to go there, and part of his thing was that he wouldn't, when he got out, he wouldn't be around another minor unsupervised. Well, he went to Texas and exposed himself to a minor. Served 10 years there, and he's been back here since 2008. But recidivism does happen because God only knows how many victims that man had before my two brothers. And yes, I am one that proudly will say that I wish he could spend the rest of his life in jail because he has proven that he cannot be rehabilitated. I'm dreading the day that my informed delivery tells me he's registered for another parole hearing, even though he can't go nowhere with a residence plan because his last one got revoked. Because y'all know I have friends in Channel 2 that are going to stay on top of it till probably after he walks out of prison. But some people would feel that, you know, they're moving on with their lives is good, but some people, that's what they choose for their career, is that they want to mess with kids. And like I said, one of my brothers, ways to cope, was trying to kill himself during recess in 5th grade. And the other one chose to cope by incesting me. I have never in my life, with everything I've been through, ever got up at this table and proposed myself to be an expert to speak for every person that's walked in the shoes that I've walked in. Because everybody has different views, everybody has different experiences, and everybody has different opinions on the outcomes of stuff that happens. And people need to keep that in mind and take lessons. And like I told you, and I'm going to tell you again, stand your ground. Don't back down. And know that from people like me, you are very much appreciated for having the backbone to even address this issue. Thank you.
Thank you so much for your testimony again, and for just kind of reiterating some of the things that we have actually talked about. Ms. Stapleton, I do want to ask you this, because if there are people who seemingly cannot be rehabilitated, if the assessment form that they take, is there something that says that these individuals cannot be rehabilitated and some other action should be taken? Are you aware of that?
Well, I know that that assessment team, that according to this thing that I read, this newspaper article, that he was evaluated and was determined, which seeks to determine whether a person can be re-entered into society. And the judge who presided over the hearing found that Mouton was a danger to society during the 2013 hearing. Mouton was ordered to register as a sex offender, his whereabouts be tracked as a GPS for the rest of his life. Well, this same judge comes forward, and after he was let out within 3 days, they were looking for him. And the judge noted on Friday, but this was some years ago, that Mouton made no attempt, at least to alert Jefferson Parish authorities about his difficulty. They literally had to do a manhunt to find you. That's my problem with that. You sought no help. And so he admitted, Mouton admitted, that he was a sexual predator to them. So it was no surprise. I mean, he knew it himself. They knew it himself. So, yeah. He admitted it. He claimed it. And like I said, you got a couple other states that they're seeing them as mentally ill for life. And then they're putting them in institutions. But that's just one person, like I said, that I knew about, Tommy Mouton.
Are we doing anything? Are we doing anything like that, of that magnitude, when we know, or individuals have said to us that they know that they have this issue and there's no help?
No, he said it, and then he was released. And the release was lifelong GPS, which did not work. I mean, within 3 days, they were looking for him.
Okay.
So we know it doesn't work. So, no, we do not have that remedy. But some other states do. But I tell you what now, when I was doing this research, I found out where there were people challenging the lifelong GPS system, that was going against their Fourth Amendment. And so some of this stuff is being challenged. So I don't know if
I read that somewhere.
Yeah, yeah. So even that kind of stuff is being challenged and being possibly overturned that we can use. And but I don't know about if a person can plead guilty to mental illness and be put in a hospital indeterminately because they are forever going to be sick, and you let them out. That's what they're going to want to do, and that's what you have with sexual predators. And look, Eddie Orange, I mean, all he did was he was sentenced to 30 years. He got 5 years probation, and he just created some more victims. There's nothing to stop people from procreating, and if they like incest, to have children. So you got two different kinds that can be lifelong offenders, and yeah, the consequences are horrible.
Okay, well, thank you both. Thank you so much again, Brandy, for inviting Miss Stapleton. Thank you for coming, and I hope that you come to our next hearing, because again, there are some questions and some things that you have brought up that I would like to ask them about and look at those, maybe that being part of the solution or part of my packet going forward in terms of legislation.
And one thing more that I had written down that I didn't bring up is truth in sentencing. I mean, because I was a victim's advocate on the front end, but when I became a victim's advocate on the back end, when these people would show up for probation and parole hearings, their shock was he was sentenced to 20 years. He's only been in there 14 years, or he's only been in there 11 years. Why am I here now? Nobody told me that there would be good time and all this other stuff that would cut that sentencing down. So victims are not told up front. Now, you know, this 20-year sentence only means such and such. So truth in sentencing, we have legal jargon that only lawyers and legislators understand. A victim doesn't even know when they go in the courtroom why that's the defendant's area. Because the first thing they would say to me is, I'm the defendant. I'm the one that needs to be defended. Why are they called the defendant? And so, you know, you have this confusion, and then so you have the truth in sentencing and that. And then another term, hard labor. I had a guy that 4 family members, he killed his 3 children and his wife, which was next of kin to this man. And he said, the DA told me I held his hand in my life for death. But he got 4 life sentences. Okay, this is a different type of crime, but this is what happens in all crimes. And he said, the DA said he'll be in for life, okay, at hard labor. So this man asked me, I want to know what he's doing. Now he thinks he's outside with a hoe. And I had to tell him, I said, you know, I hate to tell you this, I doubt very seriously if what you're thinking is what's happening. He said, no, hard labor. I want to know what he's doing. And so what did I have to do to come back? I had to come back and tell him he was in the chaplain's program. And so can I tell you, this man was just about destroyed. So they don't understand what they're hearing when they're told. They may tell them the absolute legal jargon truth, but it's not the reality truth. And I think we need to address some things that fall in the gap for victims, because they're not legal people. They are coming into a courtroom and they are being bombarded by all of this stuff, and they don't even know where to turn. So the victims' rights issue is something that could really be addressed with our pedophiles and stuff, but all across our victims' rights issues for every type of violent crime. Victims need to really understand their rights and what these words mean when they're hearing them. That was another thing. Sorry.
But you bring up a very good point, very valid as well, and we need to figure out who should be responsible for doing that. And how do we do that? What does that look like? Yeah. Okay. All right. Well, thank you very much. I appreciate both of you.
Thank you for having us.
Yes, ma'am. And again, I hope that you guys are able to come back next month.